Holy smoke. Harry's team knew Burroughs was a bust. They sued anyway. It could cost millions.
Harry may have lost more than a courtroom battle, because the explosive allegation now circling London's legal world is that Judge Nicklin has effectively frozen his path toward an appeal until a staggering $10 million payment arrives, leaving the Duke trapped between a judgment he desperately wants to challenge and a financial demand capable of tearing through the protection he believed was standing between him and disaster. Nothing about this alleged development has been officially confirmed as a separate ruling, but the timing, the figures, and the courtroom arguments have created a brutal picture. Harry wants another legal fight, Associated Newspapers wants its money, and the door to the next round appears locked while the cost decision hangs over everything. The nightmare began when Harry and the other claimants watched their case against Associated Newspapers collapse, but losing the allegations was only the opening blow, because the real shock arrived when the publisher revealed legal costs of more than $34.5 million, an extraordinary figure compared with the roughly $4.5 million budget previously approved for the defendant. That earlier figure was never necessarily a final ceiling on everything recoverable, yet the contrast was explosive, and suddenly the argument was no longer simply about who had won or lost, it was about whether 7 claimants could be pushed into an enormous personal shortfall after their insurance protection ran out the claimants reportedly hold after the event insurance covering approximately $16 million, meaning the remaining gap could climb toward $18 million if Associated Newspapers succeeds in recovering the amount it seeks. Associated Newspapers then demanded an interim payment approaching $10 million, while lawyers for the claimants argued for a lower payment, reportedly around $8 million. Judge Nicklin was therefore left staring at two furious sides, one insisting that the case had been pursued recklessly and deserved indemnity costs, the other accusing the publisher of producing an eye-watering bill wildly beyond the managed budget. And this is where the alleged frozen appeal drama erupts. Permission to pursue an appeal had not simply vanished, but consideration of that application was deferred until the costs ruling, creating the appearance that Harry was trapped in a legal corridor, unable to discover whether the next door would open until the financial consequences of the first judgment were settled. Online whispers transformed that procedural delay into a far more dramatic claim that no appeal would move until the demanded $10 million landed, but there is no confirmed public ruling establishing payment as a formal price of admission. Yet behind closed doors, the pressure would be almost impossible to ignore. Harry entered this battle believing the evidence would expose unlawful information gathering and finally deliver the reckoning he had pursued for years, only to emerge facing dismissed claims, furious accusations from the winning publisher, questions surrounding critical evidence, and a bill so large that even the insurance arranged for catastrophe may not be enough. The man who wanted vindication is now surrounded by calculations, deadlines, policies, contribution disputes, and the terrifying possibility that every additional legal move could deepen the wound. The $10 million demand is not Harry's confirmed individual bill, because liability involves all 7 claimants and remains subject to the court's determination. But gossip rarely waits for careful distinctions. The headline racing ahead of the judgment is merciless: pay first, fight later. And if Judge Nicklin ultimately allows costs far beyond the original managed figure, the biggest battle may no longer concern the Daily Mail's journalism, it may concern who pays, whose insurance responds. And whether Harry can afford to keep chasing the appeal he insists could change everything. The figures now become impossible to soften because Associated Newspapers presented costs exceeding $34.5 million. The insurance available to the claimants reportedly covers only $16 million, and the possible $18 million gap would not disappear into some distant corporate account, but could fall upon the 7 individuals who entered this courtroom believing their evidence would survive. The next danger is the basis on which those costs are assessed. Under the standard basis, spending must still be defended as proportionate and questionable charges may be reduced, while indemnity costs could push recovery much closer to the full amounts. Associated Newspapers argued that the conduct of the case justified that harsher treatment and sought an interim payment of $9.9 million, while Nicholas Bacon KC described the demand as eye-watering and proposed $9 million, leaving the judge to determine both the immediate figure and the basis of assessment before the deferred appeal application can can properly move forward. Then comes the insurance timing, and this is where the story becomes even more dangerous. The application for initial cover from Temple Legal Protection was reportedly made in March 2022, around the same period when cooperation from the central witness was allegedly breaking down. Underwriters calculate risk using the information disclosed when protection is requested, and although there is no confirmed public finding that material information was concealed, questions may now be asked about precisely what was known, what was communicated, and whether the policy responds fully. If the coverage remains valid, the claimants still confront a huge shortfall. If a dispute develops over disclosure, even the $16 million safety net could become uncertain, transforming a frightening calculation into a potentially catastrophic one. That possibility forces every claimant to examine personal exposure. Baroness Lawrence was reportedly protected through an indemnity, while Elton John publicly resisted the suggestion that unlimited personal resources should simply solve the collective problem. The other participants entered a case presented as strong, yet they may now examine the advice received, the evidence available, and the decisions that carried the litigation through an 11-week trial. Nothing publicly establishes that Harry alone owes the entire demand, but the gossip surrounding him is relentless because his name, campaign against the press, and public commitment to the case made him its most visible face. The money would still need to come from somewhere. The lifestyle business cannot casually absorb an 8-figure order. Netflix cannot be treated as an endless emergency account. Spotify is no longer the financial answer it once appeared to be, and the memoir has already passed through its largest commercial moment. Beyond those ventures sit the mortgage, security expenses, family commitments, and inherited wealth linked publicly with Princess Diana and the Queen Mother. That is why the story cuts so deeply. What was meant to protect independence could allegedly be redirected toward paying the publisher Harry tried to defeat, while Meghan watches a legal crusade become a financial reckoning. The contradiction becomes brutal. Privacy was the cause, yet the couple explained their private experiences opposite Oprah through a Netflix production and inside a memoir, giving critics an easy weapon even though voluntary disclosure does not legally excuse unlawful information gathering. Instead of vindication came dismissal, instead of damages came a cost battle, instead of immediate appellate momentum came delay. Attention therefore turns toward family. King Charles is portrayed as the one person with both the resources and emotional connection to help, but no reliable evidence shows that money has been requested or offered. Prince William represents the harder door, with reports continuing to describe deep distrust and little meaningful communication. William remains connected to Harry through the Diana Award, while the Invictus Games in Birmingham and future commemorations may place both brothers near the same national stage. Yet none of that answers the immediate question. When the cost decision arrives, will the appeal advance, will the insurance respond, or will the alleged $10 million barrier become the moment Harry discovers that fighting another round requires money before it requires arguments?